Good morning, one and all. So it is my pleasure to introduce today Dr. Piotr Alexandrowicz. He comes from the University of Poznan. Dr. Alexandrowicz graduated in law, canon law, and theology. He wrote his Doktorarbeit on canonical explanation of the freedom of contract in the Western legal tradition, and he published this work a few years ago. And then he published another book on the Decretal Intelleximus. Today, Dr. Alexandrowicz will deal with the topic of medieval canon law and freedom of contract. So it is a great pleasure for me to chair this lecture. And without further ado, I let the floor to Dr. Alexandrowicz. Thank you very much.
Thank you, Professor Beggio, for this kind introduction. Thank you, Professor Jońca, for having me. It's really a pleasure to be here. So let me start my presentation with a picture which is taken from a very nice manuscript which we have in a neighborhood of Poznań in Kurnik. And there you have these two people on the margin, which may or may not, I am not sure, may be entering into contract. So I'm not quite sure whether this is the case, but I use this image as for my book. So you will see it in a minute. And the other picture, which will introduce us to the topic, is the building of the Polish Supreme Court, when on these nice columns you can find many Latin proverbs. And one of them, which is actually hidden on the other side of the building, is Pacta sunt servanda. And this proverb is, well, traditionally linked to canon law, but this is not always the case. So for many people, these three words, Pacta sunt servanda, are, many people claim that they have originated in Roman law, and even some scholars claim so. But today I will try to prove that this is not the case, and that these words should be primarily linked with medieval canonists. So we all know that the church used to be governed by Roman law. So these famous words, Ecclesia vivit lege Romana, or this very nice saying that the jurist, the legist without knowledge of canons, matters only a little, while the canonist without knowledge of civil statutes, without knowledge of Roman law, matters nothing. So he's not competent to do his job. So what these sayings tell us, they tell that that there is a certain relation between Roman law and ecclesiastical law and canon law in the church. So the church accepted or recepted Roman law in many ways, mostly as a basic framework for its own institutions. So today we will not discuss on these general topics, and we should stress that today the traces of the influence between civil law and canon law are scarce, and this is difficult to see them. But in the past it was not the case. So there were many influences of canon law on civil law, and today we will focus on this one example, which is encapsulated by this short saying, Pacta sunt servanda. So this legal principle, I have chosen it for my research during my PhD because there are some interesting links between past problems, between challenges from the past and contemporary discussions on contract law. So I will eventually come to this point in the end of my presentation. So here you can see the cover of my book, but there are also other books related to this issue. So to relation between canon law and civil law, or the impact of canon law on civil law. And you can easily familiarize yourselves with this subject. For example, there is a very nice series in German, edited by some excellent scholars, historians of canon law, and then you can see the real scope of influence of canon law on various branches of law, on penal law, on public law, on international law. So this is really a subject which is worth research on its own. To start with medieval canon law, we have to make a very basic introduction, but as you are all familiar with the basics of Roman law, I will only touch most relevant points. So one of these points is this differentiation in Roman law between contracts and agreements. So the Romans, they have differentiated between some formal agreements, which they used to call contracts, contractus, which were entered into only by some formal requirements, either by special kind of words which need to be used, or by special kind of action that has to be performed. And only these were considered to be contracts in a strict meaning. So only these gave rise to a claim so that you can bring the other party to the court. On the other hand, they also were familiar with agreements, which are called pacta. So we will call them today agreements simply, or some informal agreements. And they have differed from contracts by this lack of formality. So they were also very popular in Roman law, but they did not give rise to a claim. So you cannot act before the court, so you cannot bring the other party to the court. You can use it to defend yourself when the other party is trying in a dispute, but they cannot be used actively. So this is a very basic distinction, which is for us a bit artificial, but this is how it looked in Roman law. Of course, there was certain kind of evolution in Roman law. So despite this sharp differentiation between these two categories, they have developed certain tools to make more and more agreements work as contracts. So they have received certain kind of formal appreciation by the courts or by certain officials in Roman law. For example, this contract of stipulation, so one of the many, the most emblematic contracts in Roman law, so a kind of very official promise or an oath, which was entered into by using special words, very precisely defined. You can see the example here. Do you promise to give me 300 sesterces? Yes, I promise. If you have used different words, it was not valid. So this contract, which was very popular, so a very general one also, it was evolving. So across the ages, there were some changes to these formal requirements. For example, at a certain point, the Romans agreed that there can be used also other kind of words to make this work, or that you can use other language, not only Latin, but also Greek to make it work. So this contract was evolving to make it more useful for practice. In the end of the, so in the 6th century, it was very flexible. So you can claim that it worked almost as a, universal kind of contract for everything, but still it was not exactly the same. So functionally, it was very similar to our, let's say, general contract, but it was the Romans did not think about it in this way. The other kind of evolution which happened, for example, and relates to this distinction between pacta and contractus, was where the agreements which were the contracts which were called in nominate. So the contracts which were based on the certain kind of duties of the two parties. And the Romans also agreed that when one party have performed her duty, the other one was forced to also to perform hers. So by this, they also accepted another general category of contracts which were not defined strictly by law to make them effective. So with these very basic remarks, we can see that the Roman law of contract was a certain kind of was organized in a way we can call it contractual nominalism. So there is a state, or there is a body of law, a civil law, or be it a law given by praetor, so a more flexible one, in which there are defined certain kind of agreements which give rise to a claim. So with these, you can go to court and you can properly defend your rights before the court. And there are also other agreements which were, to a certain extent, useful in legal practice to defend yourself, for example, or to claim something by natural law, but they cannot be used to make your claim in court. So only with this list of contracts, the state gave some certain kind of defense for the parties. And within continental Europe, within evolution of contract law in Europe, we can see a certain kind of evolution. So maybe evolution is not a proper word, but let's call it this way. So the Romans, they have developed this system of contractual nominalism, and it has evolved. So over the ages, they have made it more and more flexible. They have adapted it to legal practice. They have responded to certain needs of legal practice, and they have come very close to what we would call today freedom of contract. So the system which we are familiar with, in which the state does not define the only kind of contracts which give rise to a claim, but the state says only what in general contract has to look like. So that, for example, that it cannot be against the good customs or cannot be against the legal provisions. And if the contract meets these basic requirements, it is already valid. So the state does not enlist a particular kind of contracts, but only provide a very general definition and claims that all contracts, all agreements which are within these boundaries, they are valid and they can be used to make a claim in the court. So the Romans, they were on the way to this system which we are familiar today with, but they have not adapted it. So they stick to this contractual nominalism. They were very much so they only thought about contracts as certain boxes, different kind of contracts, which only one contract give rise to a claim, not a general category of contract. And today I will try to show you what happened, that we are what lead to this, to making this couple of steps more to reach freedom of contract. To make this, we have to first know that the medieval canon law was, well, take advantage of these developments of Roman law. So first things to learn is that they have adapted this Roman framework. So they thought about private law in Roman terms. Second thing to mention before moving into canon law is that the civil lawyers in Middle Ages, they were not interested in changing Roman law in this respect. So they have already, of course, they have developed some ideas in contract law or some new concepts, but they were not interested in building this, let's say, new paradigm of general freedom of contract, of general actionability, so giving rise of a claim from every contract. They were not interested in. The only thing that the medieval lawyers did, they provided some general labels. For example, they called these agreements, these informal agreements, which give rise to a claim, they called them naked agreements. So that these which were clothed agreements, so these which give rise to a claim, while the other agreements which were not giving rise to a claim were called bare or naked agreements, so without this claim attached to them. But they were not interested in developing this general framework. So the canonists, they had this Roman framework. They were familiar with what the civil lawyers of their time said about it, and they had some additional advantages at hand. For example, they have very, very different kind of sources at hand, and they were able to use different methods than the civil lawyers. They're also independent of Roman law in the, let's say, in this way that they can argue differently than the Romans did, because they were, well, they were serving other purpose, let's say, in general. So with the birth of canon jurisprudence in the 12th century, with this famous compilation of old laws given by Gratian around 1140, called Decretum, we can see that there is kind of movement around this doctrine. So what kind of sources did they have? For example, the canonists could have used the scripture, which was not available for the Roman lawyers, so not available. So of course they can refer to it, but it was not authoritative source of law. And if you take a look at the scripture, you can find maybe not legal provisions, but some general claims concerning or related to giving promises. For example, in the book of Numbers, when a man makes a vow to the Lord or binds himself under oath to a pledge, he shall not violate his word, but must fulfill exactly the promise he has uttered. In Psalm, you destroy those who speak falsely. In the book of Wisdom, a lying mouth destroys the soul. And more importantly, in the Gospel of Matthew, let your yes mean yes and your no mean no. Anything more is from the evil one. So in these very general statements, considering more, let's say, moral life, not necessarily legal action, we can see that in the scripture you can find many passages, well, forcing you to keep your own word. What else do they have? Well, they also have access to some ancient collections of conciliar canons and the writings of church fathers. These writings were not necessarily legal ones, but they contained also, similarly to the scripture, some passages which might be used by the canonists to make some new claims in the field of contract law. For example, there was the canon Antigonus, so a canon from the 4th century from North Africa, when there was a dispute between the bishops, and to end the dispute, the conciliar fathers said that the agreements should be kept. So either the agreements keep their durability, or the accused, unless he corrects his behavior, should be exposed to ecclesiastical discipline. Again, very general statement made only for this particular case, which was discussed at the council in the 4th century Carthage. But later, it was proved that it has some potential for making a change in legal thinking. Another example of the canon, which was very relevant, was this chapter you can see here, Juramenti. It was a passage from the writings of one of the church fathers commenting this saying of Jesus in this concerning this yes, yes, no, no. And this is quite a relevant one, so we will read it in full. So this church father said, the rationale for an oath is that everyone who swears to testify the truth. For this reason, the Lord does not want any difference between our oath and ordinary speech, as the perjury is contrary to the oath, and so in our speech there should be no lie. Both the former and the latter will be condemned by the divine judgment, as the scripture says, a lying mouth destroys the soul. So you can see here that there is no, in the God's eyes, there is no difference between oath and ordinary speech. So every kind of promise is equally relevant. And this will be used by the canonists. Another examples, one very general, just a short sentence from a long letter of Pope Gregory the Great. One should eagerly strive for the promises are put into action. So very general statement, but again, the canonists will show that it may be used as a kind of legal argument in making their own claims. The other, which was also very general, it was taken from the Council of Toledo in Spain in the 7th century. There was a very, very general statement about let's read it. So whoever promised any profit as a remuneration for somebody who will address any kind of ecclesiastical need with anyone's support, so you can see general, should be released from the promise only by its fulfillment. So this was the question that the Council Fathers had to ask, whether it was possible to free yourself from the promise given in any other way than fulfilling it. And they have said, well, it is not possible. You have to fulfill the promise. This is the only way to be released from it. And to this canon, there was given a commentary around 1190 by a famous Italian canonist Huguccio. This was a summa, so a big commentary to this Gratian Decretum. And here we can see this is the, let's say, one of two aspects marking the birth of this new thinking about contracts in the Western legal tradition. So the rise of this new argument. So what Huguccio did, he used this Roman framework, so the Roman vocabulary, and merged it with this theological thinking about promises. And out of this combination of these two elements, rise a new doctrine, which we today may a bit artificially or anachronically called freedom of contract. So they will not call it this way, but we can label it as such. So let's see what Huguccio said, commenting on this very general provision that the only way to fulfill the promise, is to realize what you have promised. There are no other options to when you have made the promise. In case there is no stipulation, already here you see, reference to Roman law, to stipulatio. When you see this general canon here, the quicunque suffragio, there is no mention about stipulatio. And what Huguccio made, he put this canon into this legal framework. So he says, in case there is no stipulation, the promisor is nevertheless obliged. So it doesn't matter what was the form of giving a promise, whether it was this official Roman contract called stipulatio or not. Even if according to civil law the promise is not binding, as it will be the case if it was only a bare agreement, he is obliged to fulfill the bare promise. Whoever will not fulfill the bare agreement will commit a sin, even if the agreement lacks certain formalities. So this is the major point, this new rise of new argument, which was by nature a theological one, but canon law is the law of the church. It serves higher purpose, salvation of souls. So reference to theological argumentation is perfectly fine. So this reference to theological argument opens some new perspectives for Huguccio. And here we can see reference to this passage from Canon Juramenti. So God does not want any difference between ordinary speech and oath, or other confirmed promise. Yeah, you can see these two canons, Quia Johannes and Juramenti. So no matter if the promisor will secure the promise or not, he will not avoid sin unless he fulfills the promise, if possible. So we can see that he has used this Roman framework, Roman vocabulary, and applied to this Roman terminology the canon law, so this new theological argument. Yeah? So the threat of sin forces us to accept that every agreement is equally binding. Yeah, so we can see that this is very in a very nice fashion. He has merged these two things. He was also very subtle in his argument. So, for example, if we go back to this canon Juramenti, we can see that there was so this church father. He mentioned only ordinary speech. So he mentioned only ordinary speech and oath. But what Huguccio included here is ordinary speech, oath, and promise. Yeah, so again, a statement considering the future, but less formal than oath. So he's very, very subtle in this argument. At the same time, around 1190, we have the rise of this new kind of argument, and we have a discovery of new kind of source. In a certain collection of extravagantes, so the passages from Old Law or the new decretals, new letters issued by Pope, which were not included in the Decretum, they were collected in this Compilatio Prima, so a book by Bernardus Papiensis. And he found an old canon, which we have already mentioned, Canon Antigonus, which was, well, Gratian was not familiar with this, but Bernardus found it and found it useful for contract law. So he decided that it will be good to have it also in the compilation and as a first canon considering contracts. You can see here, we will not go into detail here, but what he did also was that he cut some parts of it. So this is how it worked in canon. So there was a very detailed description of the canon. So considering this, the very facts of the case, here in the left column, you can see how it looked in the conciliar edition, let's say, of this canon. So there was a dispute between the bishops. Probably one of them was the heretic bishop. We can call them, he was an Arian bishop. This is how you say it in English. An Arian bishop. The other one was let's say Catholic bishop, and they have made a certain kind of agreement. Yeah, how to divide their faithful. Yeah, to make things work better in their city. Then this Arian bishop did not fulfill his promise. Yeah, so he acted against the agreement, and these church fathers gathered at this council in Carthage. They had to discuss, well, what should we do with this? Yeah, and they have said in the end, as you can see, that the peace should be kept by keeping agreements. Yeah, so he has to change his behavior, this Arian bishop. Later, what Bernard did in the second column, you can see that he cut some part of the description of the facts of the case. And after all, when this piece of legislation landed in the decretals, so in this compilation of ecclesiastical law from 1234 issued by the Pope himself, it was a very, very short one, and by this also a very general one. So later on, the canonists commented on this passage as a proclamation of the general actionability of all agreements. Yeah, so this is how it worked. So at the same moment, we have development of a new argument, we have discovery of this new legal source, and together it created a new approach to contracts. Here are some examples how it worked in practice. So again, reference to Bernard, I will skip it. For example, this is a glossa to Decretum, to this passage we have already seen in Huguccio. It seems that the promisor is obliged even by bare words when there was no oath. This is right, and we can claim that there rises a claim from bare promise, a claim founded on Canon Juramenti. So here you can see that Johannes Teutonicus, a very famous canonist, agrees with Huguccio some 25 years after him that he is correct, that should be a claim from every kind of agreement. And he already says that the claim should be founded on Canon Juramenti. So we can see in this short passage that what the canonists were up to, they had to find a solution how to make it effective in practice, because there were no tools in Roman law. Of course, as we have seen, the Roman law does not know this kind of arrangement. So they have developed various theories how to make it work in canon law. So, for example, they claim that there is a claim founded on this particular chapter from the Decretum. This is how this source looks like. The other example, so a passage from Glossa already to the Decretals. And here Bernardus of Parma says, if, however, the fulfillment of an agreement leads to the loss of the eternal salvation, the agreement is not binding. So to the other hand, so there are some boundaries to this new rule. Again, what is at stake is the eternal salvation. So the canonists, they referred regularly to these kind of arguments, to the threat of sin and to the threat of loss of salvation. Here, a very, again, interesting commentary by the Pope and also the famous canonist. Here he offers a different kind of tool to make it effective. It was a denunciation, denunciatio evangelica, so the other kind of tool which was available in canon law to make these things work. We will not go into detail, but this one is very interesting. So another 13th century canonist, Henricus de Segusio, and he makes a very nice argument. So I will read it because, well, I like this passage. And so this is clear that according to canons, from the bare agreement rises the claim. Yeah, we have already seen, we can see that the doctrine is already matured. Everyone agrees about it. As the psalmist wrote, the promise of my lips I will not alter. Before God, there is no difference between ordinary speech and oath, as it is written in Canon Grammaticus. The civil lawyers say that from bare agreement, there is no claim except for, here he makes some enumeration, the agreement which is detrimental to the eternal or temporal salvation should not be kept. Now be aware when someone agrees, as the agreements, even when they are bare, shall be fulfilled according to the truth of the gospel. So the reference again to the scripture, but a more general one. And now a very nice reference to Roman law. It makes me puzzled when any true Christian is of opposite opinion. Yeah, so if you can find a Christian which says that, well, not every agreement is binding. Because even Ulpian, the famous Roman jurist, who was a pagan, said, with this edict, the praetor supports the natural equity, protects the equity founded on the expressed agreement, as the fraud of trust is a great thing. So in general, if you just cut some part of edict, you can find this kind of general proclamation that every agreement should be kept. But, well, it was not how the Romans thought about contracts. But Hostensins used it very nicely as a rhetorical argument. Now look, if a pagan agrees for a binding force of agreement rooted in the rational equity of natural law, what should a Christian think, as he is aware that the equity of natural law is founded on law and the gospel? If a pagan says that what is durable and what is a mundane matter expressed in an agreement should be kept, what should a Catholic say about the conciliar canons and keeping agreements, as their infringement is a threat for the soul? Yes, a very nice rhetorical argument. So they were proposing a doctrine which was against Roman law, but still they have managed to use the Roman sources and Roman authorities to make their claim more attractive. Final example of medieval canonists. So one of the, well, probably the finest commentary closing the period of medieval canon law, written by Panormitanus, Bishop of Palermo. And we can see again, it's like a big summary of these 2 centuries of development of the new doctrine. It is commonly accepted that in canon law there is a claim provided by this canon, by Canon Antigonus, as whenever law approves an agreement, there must be a claim and a right to sue from such an agreement. The agreement, even if it is only a bare one, is approved and supported by the divine law according to the prophet, the promise of my lips I will not alter. Again, reference to the scripture. And similarly to oath, it is claimed that ordinary speech is valid as the party who agreed will commit a mortal sin by breaking the agreement. Whenever law orders to act, there are given both claim and objection, but canon law orders to fulfill this type of agreement, so there are given both claim and objection, as it was attested by, for example, Stienzis, André, Aquinas, and Archdeacon. So in the end, we can see already that he's referring to the other authors. So this is like a new kind of argument, so reference to communis opinio. Yes, so this is like a common opinion of learned authors that this is how it should work in canon law. So we did not go much into detail, but we can see that they have developed 3 arguments. So the one was the formal one, so the authority of legal sources. They have at hand the sources which provided them with arguments against in favor of this new solution. They have developed this theological argument, founded either on the threat of mortal sin or this more eschatological one, the loss of salvation. And thirdly, we can see here and there development of kind of practical social argument. So the reference to the social peace, that it should be kept by keeping agreements, and that agreements should have their own stability. So this is how the canonists approach the subject. This doctrine was not accepted by civil lawyers in the Middle Ages, but what we will now try to do is see how influential it was. So if you remember this picture, this was where the Romans have come. Yeah, they have stood before these doors to freedom of contract. Now, what the canons did, well, this is how I think, how I see it, is they have appeared here. Yeah, so they used this Roman framework, and they did this. So they have opened the door. Yes, so they did not want to enter, yeah, into the freedom of contract. They were not trying to make a revolution, or they did not offer a new general contract theory which will look like we know it from the codes. No, what they have offered was a different kind of argumentation, which was still within this Roman framework, but well, it opened a new access to the freedom of contract. So they did not think about contract in a way we do, but they have provided tools to make this step possible. So what happened later? Oh, now this is a so just to make a little break, we will now. I want to share with you my, let's say, side research on this pacta sunt servanda, as I have started my presentation with this saying, and I have mentioned that, well, many people today link it with Roman law, and this is not the case. So if you look at the sources, you can find very similar phrases already in Roman law, yeah, either by Praetor or in writings of Cicero. And there was a quite similar one in Antigonus, as you have seen, yeah, in the end of the canon. So pax servetur, pacta constituentur, but this is still not this particular phrase, pacta sunt servanda. So who wrote it first? So I was trying, I was familiar with these sources. I was trying to find it, and it was none of these. So you can see that Huguccio did not write it. Bernard of Parma, Goffredus, Hostensis, they used similar phrases or longer ones, or in singular, or without gerundivum. Only Antonius da Budrio, so around 1400, he used this saying, pacta sunt servanda. So as this was, well, one of many canonists from the Middle Ages, why it gained so much appreciation, how it became so popular? It was so because it was used as a summary to this canon Antigonus. So you can see the first word, Antigonus. Yeah? So this is passage from the Decretals. And before it, you can see the summary. Yeah? So this is a very similar sentence, pacta quantum cum nuda servanda sunt. So if you just skip 2 words of it, you have our famous rule. So who added these summaries? Yeah, and well, what are these summaries? They were not present in the Decretals themselves. If you go, so this is 19th century edition. Here we have 16th century edition, and these summaries are already in the printed edition. But, well, we know that they were not present in the 13th century original source. So I was trying to find out who had it. Here you have one example of many manuscripts, and there is no summary. You can see written in red, De Pactis, so the about agreements, so the new title, and already Antigonus Episcopus. Yeah, so there's no summary. So it was somewhere in between the late manuscripts and between the early modern printing. So I tried to incunabula, yeah, so in these first printed books. And then this is the moment when it has changed. Yeah? So if you take a look at the older editions up to 1489, there were no summaries added. And everything has changed with the cooperation between the famous Venetian editor, Battista Torti, and the canonist, Girolamo Chiari. So he paid the canonist, or experienced lawyer, but he also was a civil lawyer. He paid him to make new editions more attractive. And this, expert provided him with new tools. He excerpted parts of commentaries of medieval books, of manuscripts. Well, maybe we can add this one as a summary. Maybe we can add these to make things more clear. Maybe students will appreciate when we will use these passages on sides of our new books. Yeah, and this is this edition. Yeah, so for the first time it was added here, this Pacta reference, and this is why it was so popular. And in this form, it was written by Panormitanus, Nicolo de Tudesci. It was just a summary right at the beginning of his commentary to this chapter. So it is quite complicated. And I think that in the end of the day, we can say these two things, that the canonists, well, they were the first one to discover the freedom of contract, and they formulated the Pacta Maxim, but only indirectly we know it from them. Because now, as we go back to our story, because just side discourse, yeah, we are here. Yeah, so the beginning of the early modernity, we have Roman framework, we have new arguments, and now what happened later? So you have already seen these arguments. We have this medieval heritage and legal pluralism, everything is changing. We have new methods of studying law, new legal schools. And now what I will try to show you is how these arguments of the canonists were accepted or, well, were not accepted by the later schools. So to make things easier, I have just classified the authors into some major groups. So this is like a standard way of thinking about development of legal doctrine. Of course, it is a bit artificial, but I think it makes things easier. Well, pars pro toto, we can examine how certain things evolved over the course of time. So in canon law, well, certainly there were also later commentaries of canon law on this topic, and these are part of my current research. So these late commentaries to the Decretals, and you can find the same arguments there. But the impact of canonists on civil law in this period, so after 1500, was declining. Yeah, so it was smaller and smaller, and they were not actually that relevant for the civil law doctrine. So they have developed some historical arguments. They made new references to civil law, but these canonists were not that influential as the canonists in Middle Ages. So this is not how the canon law argumentation made it to civil law doctrine. Maybe the other way was possible. So using the new school of thinking about law, the early modern scholasticism, so the merging of various traditions. So Aristotle plus Aquinas plus Roman law and canon law, it was all reinterpreted in the early modern period by the moral theologians. So the theologians who were serving as confessors or as advisors to the priests, to the princes, to the kings, to the merchants, and because they were advising to these people, they have to be familiar with the very complicated issues connected with contract law of the time. And you can imagine that in the 16th century, there were many new issues, many new challenges, considering the development of, the discovery, so-called, of America, or the new institutions in trade law. And there were many institutions, many instruments developed by merchants to make things working properly for them, yeah, to arrange the new commercial world. So these things were quite complicated, and theologians thought, well, contracts involve actions of ordinary people, so this is a matter which is maybe called morally relevant. Yeah, so we have to be familiar with it to evaluate properly the actions of these people. So and they were very influential people. So within this second scholasticism, as it is called, and this book, well, I've not mentioned it, by Wim de Kock. This is the best introduction to the topic, and a great book. And also the author is a very nice scholar, and I recommend it to you. So just a couple of examples how these people, how these scholars, they were usually moral theologians or canon lawyers, how they discussed this topic. For example, Diego de Covarrubias. Some authors claim against the common opinion that even in civil law from the bare agreement there rises a civil obligation and there is given a claim. It may be proved this way. In the matters considering sin, it is a papal law that should be followed also in civil form and not civil law, as papal law provides a claim from the bare agreement. Since when canon law prohibits something due to the reason of sin, civil law cannot allow it, and if it does, papal law should prevail. Okay, so in general, he was discussing the things, which law should be applied to contracts. Yeah, here sin is involved. There is a threat of sin. We should apply canon law, and in canon law, every agreement is binding. The other example, a very different kind of work. So this is a manual for confessors on the 8th commandment. So you shall not lie. You shall not bear foul witness. Who does not fulfill the obligation from a promise commits a mortal sin. This type of lie is especially malevolent, namely not to fulfill one's trust and promise. Both natural law and canon law oblige to do so. Again, general reception of this way of thinking, but without reference to the proper sources. very famous author from the Low Countries, Leonardus Decius. The party to an agreement is obliged to fulfill the promise and respect the trust of the other party eagerly and steadily. On the ecclesiastical forum and everywhere where the canon law is applied in courts, it is encouraged to honor the contracts and to fulfill the promises, as Covarrubias and Silvestre teach, and as it is obvious from Canon Antigonus, which you are familiar with, as the learned authors notice. The reason behind this approach is that canon law, which is established for the sake of the salvation of souls, does take into account the obligations of conscience and demands their performance unless there occurs mistake or fraud. So in the end, you can see some glimpses of the general thinking about contracts, yes, so general categories of mistake and fraud. But earlier you can see also these arguments developed by canonists, yes, so the threat of sin and the relevance of the forum of conscience, so the internal forum, also for external affairs. We skip Juan de Valero and we go to Pedro de Oñate, a very massive commentary on contracts. And he provided just a very nice summary to how these things were perceived by the second scholastics. Natural law, canon law, and Hispanic law entirely agree, and innumerable difficulties, frauds, litigations, and disputes have been removed, thanks to such great consensus and clarity in the laws. So you can see this. He provides a big picture. Yeah? So now this is the middle of the 17th century. Everything is in harmony. To the contracting parties, liberty was very wisely being restored, so that whenever they want to bind themselves through concluding a contract about their goods, this contract will be recognized by whichever of both courts before they will have brought their case, and it will be upheld as being sacrosanct and inviolable. Therefore, canon law and Hispanic law correct the jus commune, by meaning Roman law, since the former grant an action and civil obligation to all bare agreements, while the latter denied them just that. Yes, so the Roman law denied the agreements only the claim. Yes, so it seems not that relevant, but as we have seen in the structure of Roman framework of contract law, it was very relevant. Now he says that everything is in harmony. So the natural law and canon law has changed this Roman law, and today every contract is binding. So by the middle of the 17th century, this was quite popular view, not only by these theologians. So what we can say about them? So they are familiar with arguments of medieval canonists. They are familiar with these sources, but well, they developed the doctrine in a new direction. They provide some more general statements about contracts. Maybe there was a certain kind of influence of medieval law on legal humanism. Certainly not. So these authors were not interested in the arguments of canon law. They were interested in studying Roman law in its original context, providing some historical introduction to Roman law, and searching for the true meaning of the original source. So they were strictly following Roman law. They were usually hostile towards canon law, and they claimed that there is no actionability of bare agreements. So if you take a look in 16th or 17th century authors like Conan, Coujat, Donat, or Favre, you will see that they are hostile toward canon law, and there is no actionability of bare agreements in Roman law. So this was certainly not the way to transfer this medieval argument to contemporary dispute. Maybe Dutch elegant jurisprudence. So they were somewhere in the middle. So they were using methods of legal humanists, but they were also referring very much into the local practice, not that as humanists did. And we can see the very nice example how they combine these all arguments into one narrative. So one of the famous authors from this, one of the precursors of this Dutch elegant jurisprudence, Wezenbeck. It is common opinion, and so it is observed in practice, that today all agreements are indiscriminately actionable, even in the civil courts. So you can see very straightforwardly he put it, every agreement is binding. I think this opinion is true and must be followed. For since agreements are binding naturally and as a matter of equity, it follows that he who does not keep an agreement acts and sins against nature, conscience, and therefore against the duty of a good man. So we have this theological argument, but only as part of the bigger claim. Yeah. So he acts against conscience, against a duty of good men. So this is a very general, let's say, moral standard. As the canonists wish, this is a mortal sin. And surely, in his first letter to the Romans, Paul includes those who do not keep their agreements among those who commit a capital crime. Now it is established among doctors that each time we are dealing with protection from sin and a matter of conscience, even in the civil court, the canon law has to be observed. So you can see he was familiar with canon law, but more relevant was for him actual legal practice. So also here we cannot say that there was a transfer of this argumentation into the civil law discourse. School of Law of Nature was next step. So they used mostly the teachings of the moral scholastics and framed it without references to the Christian theology. So they based their claims on natural law. They perceived humans as social creatures and used the reference to reasonable nature of man as a general source of law. So they used similar arguments, but without referring to theology, to theological arguments, or to the Bible. So they were Christians, but they have changed the argument into more, let's say, secular one. Of course, Grotius is complicated, but he did not use this theological arguments. So I only can add this at the moment. But take a look at Samuel Pufendorf. He says, although the nature and kind of agreements entered into by individuals depend on each person's judgment, yet the law of nature commands in a general way and indefinitely that human beings enter into agreements of some kind or other, since without them social relations and peace cannot be preserved. Now, whenever human beings enter into any agreements, human sociability requires that the agreements be faithfully observed. So a general reference to the condition of man, to the nature of man, is enough to provide a justification for keeping agreements. So the result, the outcome, is the same as in medieval canon law, but the arguments used are very different. Although they have used very widely these moral theologians of second scholasticism, but they did not provide references to them. So there was a very interesting transfer of ideas between these two schools. And finally, usus modernus pandectarum, so the new reception of Roman law, mostly in the German area. So they have studied Roman law with strong references to local German customs and tried to apply it to Roman law and these local German laws to make it to depict how the legal practice looked like in Germany at this time. They have also a great influence on German historical school and on German codification. Here, just a small passage. It is like a note in Syntagma by Struvius, and this was written by Peter Müller. So how he perceived these canon law arguments. And so many authors, and Wesenbeck among them, claim that in canon law there is given a claim from a bare agreement, because the aim of canon law is to bring back the natural equity of civil law and to mitigate its strictness. This aim is proved by Canon Antigonus and Canon Qualiter, but there is no more said about the claim than in civil law. So he is familiar with the sources, yeah, but let's look what he does with them. It should be stated clearly that any change or correction of civil law by canon law should not be accepted unless it is explicit. And it is not certain to claim that canon law intends to fulfill the agreements and to provide exceptions and claims from agreements, since it is accepted that agreements are fulfilled after exceptions are granted, and in similar way to what Piotr said, that he had been protecting the agreements. So it is a bit complicated, but what he's trying to say that he makes the point like this. In this passage, in Canon Antigonus, there is no reference to contracts, no reference to stipulatio, no reference to promise. Yeah? And now we cannot argue from this short passage from 4th century that in canon law, every agreement should give rise to a claim. So he's very familiar with the source, but he says, well, in canon law, they have gone the wrong way. So they have developed this new doctrine, but they do not have basis for this. So we better refer to local practice, or we better refer to ancient German customs. And then you can find also some very general sayings like ein Mann, ein Wort, ein Wort. So like they preferred to look for the origins of this general actionability of contracts, of agreements in all the German customs than in canon law. So it was also not by this legal school that the transfer of canon law argumentation made it to civil law. So if you could just take a short look at the general scheme. So we have seen these arguments in canon law, it was not relevant, mostly in late scholasticism. They have influenced the school of law of nature, and school of law of nature had some influence either on usus modernus or on codifications, especially in the early 19th century. So by this way, we can see that this argument transformed, lost this religious, let's say, impact, and was transformed into more secular one, and it affected codifications. So how does it look today? yeah, after this long story, what do we have in the codes? This is again just a very briefly. So today we have this general concept of contract, which is given in the code. So if you take a look at just couple of these legal provisions, we can see the general definitions of contract, or claims that all contracts have the force of law. The contract has the force of law amongst the parties. The obligations born of contract have the force of law among the parties to the contract and must be performed according to their terms. So very general statements, but providing this new narrative about contracts. So now we do not have to define every type of contract. We do not have to make this enumeration of contracts which are actionable. No, we make a general claim. We create this general framework for contract law, general theory of contract, that the contract defining some general characteristics of every kind of agreement. And we claim then that all these are binding. And why? Well, because the code says so. So now in civil law tradition in the continent, there is hardly anyone who is thinking about this question. Yeah? So why is the contract binding? Well, we have it in the code. Yeah, we have freedom of contract in the code. So we just refer to the proper provision from the civil code, and the claim is over. Yeah, so the agreement is binding, the contract is binding. So this question, which was in the beginning of this whole issue, now lost its significance due to codification. So with codification, this dispute about moral fundamentals of contract, the new argumentation, this theological argument or a secular one, it lost its relevance, but not everywhere, since not everywhere we have codes. If you take a look at common law, so there is a very relevant part of private law, which is called contract theory. And this is these are theories which are not present in continental Europe, because they are trying to answer the question, what makes a contract and why contract is valid. So we simply refer to code. Yeah? And the code says what is a contract, and now the contract is valid because the code says so. We have this general theory of contract. They do not have code. The contract law is not codified, although there are some statutes concerning contract, but in general they are not defined by the code. So they have to develop various kind of theories to argue what is the contract and why contract is binding. So they are asking similar questions as the legal scholars did in the past. So for example, you can see just a very basic list of various, and these are not all, various theories of contract explaining why the contract is kept. So either it is kept because it is founded on promise, either it is kept because it is founded on the reliance, so you cannot fail to the trust which was put in you by the other party, or you can refer to efficiency theory, so to the bargaining parties, that it is better for everyone to keep it because this will keep your bargaining. So various kinds of arguments which are being developed. And this is why I've chosen this subject for my research in PhD. So you can see some similarities between these arguments developed by canonists and these arguments being developed today in contract theory. So it's difficult to link them directly, but the way of thinking about contract is the same. So today we are here, we have freedom of contract. And I think this is, there is a point in thinking about why contracts are binding. So to bring this discussion into continental law, you can use, legal history research. You can work on medieval canon law, for example, search for some ideas and, bring some fresh air into the dogmatics, into the legal positive law about contracts when there are some issues discussed by the court, and the court needs some new kind of arguments to provide an equitable solution to the case. Or you can make reference to the other tradition, to the contract theory in common law, which also gives us a new kind of thinking about contracts. So this is how I see this very in a grand scheme, this development from Roman law, medieval canon law, through early modern reception or rejection up to today. And I think this is quite useful to think about contracts also without limiting ourselves to the abstract and general principles from the code, but thinking about contracts in a more general way and asking philosophical questions, because this is, this brings contracts to life, let's say. Thank you very much. That's all what I want to say.